Lawyer with Flora Pettit here in Charlottesville, and I do a fair amount of real estate litigation. And this presentation follows on the one that John Altmiller did, and provides a little more substantive detail on some of the topics that John raised. John introduced a couple of topics about real estate litigation, and when I'm talking about real estate litigation for purposes of this segment, what I'm really talking about is ownership issues. We're not talking about easements, we're talking about ownership. And John had referred to actions to quiet title and actions for adverse possession. And what I'm going to do is I'm going to talk a little bit more about those and a little bit more about what the practitioner should be considering when those types of issues come through their door. And an action to quiet title, adverse possession is a method of proving title. And understanding how to prove title in Virginia is very important because it includes a trap for the unwary. And that trap is this. If you are going to bring an action to establish title to property, if you've got a dispute with your neighbor over where your boundary line is, if you've got a dispute over ownership of a parcel of property, the law in Virginia is that you have to recover on the strength of your own title, not the weakness of your opposing party's title. And so that's what I want everybody who's listening today or watching today to take away is if you file the action, you have the burden of proof, and you have to meet that burden. Because if you fail to meet that burden, you lose. Even if the other party's title is not as strong as yours, if you fail to meet the elements of legal title, you will lose, and your opponent will end up with owning the property. So when somebody walks into your office and they say they believe they own this particular parcel of property and that their neighbor is encroaching on it in some way, the first thing you want to do is figure out how you're going to be able to prove title. And in Virginia, there's a couple of different ways to do it. One is, and this would be the most challenging one, which is to trace the title back to the Commonwealth. In other words, you've got to trace your title back to a king's grant in order to establish legal title to property. Most people can't do that because most of the records don't go back that far. You've got courthouse fires that have happened in a number of circuits, and the records just don't exist. So what most people do is prove legal title by tracing title back to a common grantor. And if you think about it, by tracing title of the two properties back to a common grantor, you're essentially setting up an estoppel. If your title and their title both come from the same person, then neither of you can really complain about the validity of the other's title. So that is typically what happens, is you get a title searcher. Title searcher traces both parcels back. If you're dealing with a residential subdivision, this is very easy because you trace it back to whoever the developer was. And that's usually a pretty quick and pretty simple exercise. It gets more challenging when you're in rural properties because some of those larger properties really can come from, they have different chains of title. And I've had circumstances where I've gone back to the early 1800s and still not found a common grant. So it is very important when you're advising a client and someone comes through the door to think about proof and how you're going to do it and if you can do it, because if you cannot do it, you should not be filing a complaint. So the title search is really a critical tool here. The title search to find, again, chances of tracing to a king's grant are pretty limited. So you need to be able to find a common grantor. If you can't trace your title to the Commonwealth and you can't trace your title to a common grantor, then the final way to prove title is through adverse possession. And obviously that's a very fact-intensive inquiry, and it depends on you're actually using and occupying the property. The elements of adverse possession, are that it be actual, which means you actually have to be using or possessing the property. That it be open and notorious, which means it's got to be obvious to somebody else that you are using the property and purport to claim it as your own. That's an issue if you're talking about a wooded property. hard to prove actual use and possession of a wooded property unless you're fencing it. It's got to be continuous, which means that it has to be essentially without interruption for the 15-year statutory period for establishing title by adverse possession. It's got to be, I got open and notorious, so actual, open and notorious, continuous, hostile, and then under a claim of right. And those last two, hostile and under a claim of right, are the two that I think create the most confusion. A lot of people think that hostile means you have to be intending to take somebody else's property, and that is not the case. In Virginia, like in the majority of jurisdictions in the United States, the possession is hostile if you believe you own your property up to a particular line on the ground. And you can be mistaken about where that line is, but as long as you think you own it to a particular line on the ground, then that's hostile. And just to be clear, even though you're mistaken, it can still be hostile, because the idea is the hostility relates to the use and the possession of property that's not your own, not necessarily to your intent to take somebody else's property. And finally, claim of right. A lot of people think that a claim of right means that you've got some color of title, or you've got some documentation of some claim to that property, and that's not the case. A claim of right can be proven by occupation and use. So if you think about all of those elements of adverse possession, it's got to be actual, it's got to be open and notorious, it's got to be continuous, it's got to be hostile, and it's got to be under a claim of right. All of those can be proven by showing that you actually use and possess the property. And some of the examples that have come up and that you would see, for example, in a suburban context are if you mow property and you plant flowers on it, you think your boundary line goes up to a particular area, and for 15 years you mow that area and you plant flowers on it and you treat it as your own under principles of adverse possession, then you can prove title by adverse possession to that property. But those are the three things that you have to be ready. One of those three things are what you have to prove if you're going to go into court on a claim where you're going to try to establish title to somebody else's property. And it's very important to understand that, and it's also very important to understand that if you cannot prove title through one of those methods, then you have no business filing suit. Because again, in Virginia, and this is what I want everybody to walk away with, you have to recover on the strength of your own title, not on the weakness of the opponent's. If you cannot establish title through one of those three ways and you want to acquire ownership of the property, then you're going to have to engage in some type of activity that would encourage your neighboring property owner to sue you. Because if they sue you and they have the same problems with proving title, then you win by default. Now that we've talked about how to prove title in Virginia, the next question is, what is the procedural mechanism that you're going to use? Assuming that you've determined that you can prove title by one of those three ways, the question, you then have to answer the question of what's the procedural vehicle to use. And there's essentially three primary ways to try title in Virginia. There's an action to quiet title, which is now governed by statute. It's in 55.1. There is an action to establish boundaries, which is in Title 8.01, and there's also an action for ejectment, which is also in Title 8.01. And these are all common law actions that are now codified by statute, and they apply in different circumstances. A quiet title action is one where you simply file suit to the court and you say, we have a dispute over title, that this adjoining property owner or this person has a claim to my title that creates a cloud on that title that needs to be removed. Typically you do that because what you're trying to do is you're trying to sell your property and there's some kind of encumbrance and cloud or something else on the property, and you want to quiet the title so that you can have marketable title and sell it to and convey your property. So at common law, that action only was available if you were in possession of the property. that the idea was that was an equitable action. The ejectment action, which we'll get to momentarily, was an action at law that gave a cause of action to an owner who was out of possession to eject somebody who was unlawfully possessing their property. So quiet title being an equitable action requiring no adequate remedy at law was limited at the time to a plaintiff who was in possession. By statute, that has changed. Now you can file an action to quiet title whether you were in or out of possession. And again, you have all what you need to do and what you need to understand to go to court is that you have to be able to prove your title in one of the three ways that we've discussed, and you have to demonstrate that somebody has a cloud on the title. And again, a cloud on the title can be one that is reflected in the real estate title records, whether it be some conflict in terms of boundary lines or something else. It can also be somebody's unlawfully possessing your property. It can be that somebody is claiming title by adverse possession to your property. There's a whole host of different ways that you can show a cloud on title, which allows you to go into court and have that court quiet title. Another action, and this is for those of you who have a transactional practice, a quiet title action often is done in conjunction with title insurance companies. So, for example, if you've got a sale, title insurance company comes up with a title commitment, and there are exceptions to that title commitment because there are certain clouds on title that they identify that they're not going to insure over, that are going to be difficult in terms of marking that property or closing on the property. Oftentimes, what will happen is you will as a litigator, you will work with that title company. You will identify precisely what the cloud on the title is. You will work with the title company when you draft up your complaint to make sure that they're comfortable with what that complaint says. That title company will also review and weigh in on the text of the order that ultimately you hope to have you have entered by the court, so that you're satisfying the title company with respect to the title issue. So I think most often, for those of you who do not litigate, typically you're going to see these issues come up in transactions when the title commitments raise a red flag. So moving on from actions to quiet title, an action to establish boundaries, that's typically used, again, that's a statutory action that is typically used where if you've got a neighboring property owner and there's a dispute over your property line. That dispute can be because there are conflicts in the property descriptions between the two properties, and again, you have to be able to prove title, legal title to the property that you're claiming, and you also have to have a survey in that instance, and the court can order the survey by statute. But that would be one avenue that typically you would use if there's an adverse possession claim. If somebody appears as if they're trying to encroach on your boundary line, an action to establish boundaries would be a useful tool for that. And then finally, ejectment, which is, again, at common law, was an action at law to remove someone who's unlawfully possessing property, and now is governed by statute, but still is only available to a plaintiff who is out of possession. So in other words, in that case, somebody has to actually be occupying your property. And what this does is it tries title. You've got to prove title to the property. You've got to prove the right to possession, which typically follows title unless the property is subject to a lease. And then what you can do if you prove those things is you can have the court eject the person who's unlawfully possessing your property. So those are the three primary tools. A lot of times you will see people call these actions for declaratory judgment because you can do that. You don't have to. It can be just simply a quiet title action, or an action to establish boundaries, or an action for ejectment. But oftentimes you do see people label these as declaratory judgment actions, and that's fine. I mean, a declaratory judgment action is simply a procedural vehicle to assert what is an underlying cause of action. These are your underlying causes of action. So we've now covered how you prove title, and what the procedural vehicles are for trying title. And Those are the primary tools that you need to be, as a practitioner, to be able to assess when somebody walks in your office whether they have a viable cause of action, whether they can prove title, and what's the appropriate procedural vehicle for trying that case. And again, if you can't answer the first question, which is how to prove title, you should stop right there and think about how else to resolve your problem. If you can prove title, then you move on to what's the appropriate vehicle. So with that, I think those are the basic tools that any practitioner needs when somebody walks into their office with a title issue. And that's the framework through which you should discuss with your client how you want to solve whatever problem they have with respect to their title. Thank you.